My learned brothers and sisters, this is Advocate A.DEVMORARI talking to you from Ahmedabad city, Gujarat state, India, that is our Bharat. Today I have selected a very interesting topic, that is quashing of FR and charge sheet under section 5 to 8 of Bharatiya Nagarik Suraksha Sanhita 2023, Constitution of India 1950, Article 2 to 6. Inherent power given to Honorable High Court under section 5 to 8, previously it was known as section CRP section 482, is with purpose and object of advancement of justice. Touchstone for exercising that power would be to secure ends of justice. Ends of justice are higher than ends of mere law, through justice as God, to be administered in accordance with laws enacted by legislature. Now, in following categories of cases, I'll mention a few. The High Court may, in exercise of powers under Article 26 of our Constitution or under Section 5 to 8 of BNSS and previously known as Criminal Procedure Code Section 482, may interfere in proceedings relating to cognizable offences to prevent abuse of the process of any court or otherwise to secure the ends of justice. However, powers should be exercised sparingly, and that too in the rarest of the rare cases. Now, there are certain categories of the cases for which Honorable and Learned High Court can exercise inherent powers. Number one, if there is no prima facie evidence in the FR, that is cognizable offence, then there is no sufficient ground for proceeding with the trial against the accused. What do you mean by prima facie evidence? Prima facie evidence means taking cognizance of the offence. And prima facie evidence cannot be judged simply by the FR. It has to be judged by the evidence adduced along with the FIR. Allegations in the FR may constitute an offence, but if those allegations are not supported by legally admissible evidence, then there is no sufficient ground for proceeding with the trial against the accused. Now, there are two sections of FR. Previously, in criminal procedure, there was section 154 and 155. Now, 173 and 175. Where the allegations of the first information report and other materials, if any, accompanying the FR do not disclose a cognizable offence, justifying an investigation by a police officer under section 175, except under the order of magistrate within the purview of section 155 subsection 2 of old CRPC, and now it is BNS 174. It means there must be cognizable offence in FIR. When the uncontroverted allegations made in the FIR or complaint and the evidence collected in support of the same do not disclose the commission of any offence and make out a case against the accused, then also there is no sufficient ground for proceeding with the trial against the accused. But the allegations in the FIR do not constitute a cognizable offence but constitute only a non-cognizable offence. No investigation is permitted by a police officer without an order of a magistrate as contemplated in section 174 of BNSS, then a new law. When the allegations made in the FIR or complaint are so absurd and inherently improbable on the basis of which no prudent person can ever reach a just conclusion that there is sufficient ground for proceeding with the trial against the accused. Where there is an express legal bar engrafted in any of the provisions of the code or the concerned act under which a criminal proceeding is instituted to the institution and continuance of the proceedings, and or where there is a specific provision in the code or the concerned act providing efficacious redress for the grievance of the aggrieved party. Where a criminal proceeding is manifestly attended with malafide, and or where the proceeding is maliciously instituted with an ulterior motive for taking vengeance on the accused and with a view to spite him due to private and personal grudge. These are some categories of the cases where FIR can be quashed. Now in this new section of FIR, BNS section 173, instead of 154, instead of 154, now it is 173. There is a provision in this FIR, provided that, I'll read out. If the information is given by the woman or any woman against whom an offense under section, the number of sections I'll just read out: 64, 65, 66, 67, 68, 69, 70, 71, 74, 75, 76, 77, 78, 79, or section 124 of the Bharatiya Nyaya Sanhita 2023 is alleged to have been committed or attempted to be committed, then such information, I will emphasize, then such information shall be recorded by a woman police officer or any woman officer, not by PSO. This is the mandatory provision. If police officer has registered a FIR of any woman by violating these provisions, then accused can go for discharge or can go for quashing the FIR. Prosecution for contempt of lawful authority of public servant, for offences against public justice, and for offences relating to documents given in evidence. For this, if government servant has lodged FIR against accused, then accused can go for discharge or for quashing. For example, for any government servant from honorable court even, or from government office has come for execution of some order to you, and you are not allowing him, you are arresting, or you are एक थप्पड़ मार के भगा दिया, and if that man goes to the police station to have a FIR against you, then that FIR is not valid. Why? Because that person will say FIR against the person, it is illegal, because there is express legal bar engrafted by the law of the land. It is against specific provision of BNS section 215. It is violation of BNS section 215. Then what is the remedy? That person, his superior, has to go to the court and register the complaint before the court. That is the valid procedure. Needless to emphasize, the sexual offences which are grave, heinous, and gruesome in nature shall never be the subject matter of the compromise. This is for general knowledge. Nonetheless, such powers of wide amplitude ought to be exercised carefully in the context of causing criminal proceedings, bearing in mind There are certain points which are to be kept in mind for quashing. When you go for quashing before Honorable Court, you have to, any learned lawyer has to keep these points in the mind whether this case is for quashing or not. Number one, the nature and the effect of the offense on the consciousness of the society. Number two, the seriousness of the injury, if any. Number three, voluntary nature of compromise between the accused and the victim. Number four, and conduct of the accused person prior to and after the occurrence of the purported offense or other relevant considerations. These are the points to be observed while deciding quashing petition. Well, all these arguments are based on two citations. Number one, Ram Gopal State of Madhya Pradesh, Ram Gopal versus State of Madhya Pradesh, 2021, 5 KLT 601 Supreme Court. Another one is very famous citation, year 1992 Supreme Court 604, State of Haryana versus Chief Minister Bhajanlal. And law is also very clear about this. So on the basis of these three things, provision of the law and these two citations, I have prepared these arguments, this video for your kind information to increase your knowledge. Any lawyer or a man with dignity who is harassed by other persons without any reason can go for quashing and declare himself as innocent. Hope you have got some information, vital information, useful information from this video. Subscribe it, share it, enjoy it. And I'll see you in the next video. That is also very interesting. And let us live in the kingdom of joy, the kingdom of happiness. Thank you very much. Thank you very much. Thank you very much.